Kelley to take you on the journey. Thanks,
Thank
Barry.
you very, Thanks very much for that very kind introduction, Chris. And yeah, just want to reiterate, obviously, that there's a long-standing partnership between our two organisations, and yeah, we really appreciate the opportunity to come and speak to the membership as we do every now and then. So, as Chris has already laid out, we're going to talk. We're going to use this recent decision that's been handed down by the federal court as a bit of a jumping off point to have a little bit of a broader sort of discussion about some pretty topical issues that relate to the matters that were considered in that decision. And as Chris has already said, I'll be ably assisted by Christian on some of the slides there. So we go to the next slide, please. So Chris has. Oh, okay, yep. So we've already had an acknowledgement of country. So we'll go forward to just talking a little bit about the overview of what we're going to cover. So first of all, as I said, we're gonna start by looking at this Coles and Woolworths decision. Christian's going to give you a bit of an idea of the facts of the case and the relevant background, so that then we can kind of go through and unpack a little bit some of the areas where Coles and Woolies came unstuck in this particular litigation. But obviously, what's really relevant for everybody here today is how that's relevant for your own businesses and what the sort of broader implications of that decision are. Um, because of the nature of the issues that Coles and Woolies had, we're going to be focusing primarily on the position for salaried employees, so employees that are remunerated on an annual salary, but who are also covered by modern awards. I'll just note as a kind of general proviso at the outset that a lot of the observations we'll be making in relation to modern awards would technically apply equally to employees that are covered by enterprise agreements. But generally speaking, when businesses have enterprise agreements, the situation is a little bit different because they will have negotiated those agreements themselves and have gone through the process of benchmarking them against the award and all those other things that are necessary for approval. So while a lot of those same observations do apply, we'll be focusing on modern awards rather than enterprise agreements. A, because that was what happened in the Woolworths case, and B, because it's just got slightly more broad application to a lot of people, a lot of businesses, I should say, and C, because there's that added trick with modern awards where sometimes, as I said, less common with an enterprise agreement that people just don't know that it exists at all or that it applies. With modern awards, sometimes people are caught completely off guard about the fact that a modern award actually applies to their business or to particular employees. So we're going to talk a little bit about some of the common misconceptions surrounding, the interaction between salaried employees who are usually engaged on some type of contract and the other sort of terms and conditions that apply to their employment through modern awards. We're going to look specifically at a few different sort of tools that can be used to manage all these sorts of risks. Obviously, one of the key ones is employment agreements. And some of you may be familiar with the idea of sort of set-off clauses, as they're called. Christian will talk a little bit about what those are, and then I will talk a little bit about the particular issues that Coles and Woolworths had in terms of or especially we'll use an example from the Woolworths part of the decision to just talk about the limitations and potential pitfalls of taking that type of approach. Because while employment agreements are a really critical tool for managing those risks and setting up the parameters of the engagement, they do have sort of limitations because of those other requirements that sort of come in from other areas such as modern awards or the Fair Work Act. As Chris said at the beginning, a big part of the decision, the Coles and Woolies decision, was kind of focusing on overtime, underpayments for overtime, but that also ties in with the sort of record keeping side of things as well. And that's potentially the part of this decision that caused the biggest stir for a lot of people, because it did really suggest that a lot of established practices, even for really big well-resourced organisations like Coles and Woolies, were not sufficient to discharge relevant obligations under the regulations. And again, that's something that has particular resonance in the case of salaried employees, just because a lot of ideally the whole attraction of paying an employee on a salary is that it's got a bit of a set and forget. You kind of decide in advance this will be your remuneration for the year. You kind of pay them those regular payments, and then you don't ideally don't have to worry about sort of tracking exact hours of work. Typically, employment agreements will say something about compensation being included for reasonable additional hours and so forth. But yeah, we're just going to unpack some of the wrinkles that have kind of emerged from this decision in terms of those types of arrangements. And then throughout, we'll sort of be talking a little bit about some of the sort of takeaways and practical tips and what you can do to kind of protect your business against these types of risks. And then at the end, we'll kind of sum up a little bit as well with some more of those kind of key takeaways and conclusions. So if we could go to the next slide, please. I'll hand over to Christian.
Perfect. Thank you, by the way, Chris, and also Barney for the introductions. So Barney's given a bit of an overview, but I'm going to drill down just quickly on a few of the numbers, a bit of the background of the Coles and Woolies case. So for those who aren't aware, handed down in September last year on the 5th, but in the Federal Court of Australia. It was 4 parallel proceedings which were brought against Coles and Woolworths by both the Fair Work Ombudsman and class action claimants. The proceedings, as Barney touched on, were centred on the underpayment allegations of approximately 19,000 Woolworths employees between 2015 and 2019, and 8,700 Coles employees between 2017 and 2020. All of which were white-collar salaried managers or team leaders. So if you can imagine, that's almost 30,000 employees, so size of roughly a small suburb. So these issues were far-reaching and also spanned significant periods of time. The employees themselves were covered by the General Retail Industry Award 2010. And the companies were relying on annual salaries and set-off clauses, which we'll touch on in further detail, in their employment contracts to manage overtime, penalty entitlements, and other award-based entitlements. So broadly, as Barney did touch on as well, the court found that the companies failed to pay these award entitlements that were due in each specific pay period. And the court also found failures in their record-keeping practices. The financial fallout from the decision was enormous. If you haven't heard already, it's estimated that the combined total remediation costs between the two retailers could be pushing up to $1 billion. Coles expects a further $250 million in remediation costs on top of millions they've already paid, since they conducted their own review prior to the decision actually being handed down. Woolies is expecting worse and has assessed costs could be near 700 million gross, including interest on some superannuation and payroll tax to be added to their net liability. There is a further directions hearing set next month, actually, which will address the final compensation and penalties in the case. So stay tuned. Those decisions will be handed down next month.
And sorry, just really quickly, I can see Chris has raised the very relevant point of whether decisions being appealed. And just while you're on that point, Christian,
Yes.
about further hearings to come, the penalty decision still hasn't been handed down, and it is expected that at least some aspects of the decision will be appealed. So it's probably likely to stay in the headlines for quite some time. But there are some aspects of this decision that, in our view, are probably likely to survive appeal. So for the time being, kind of best practice is to operate on the assumption, that this is probably likely to stay as is. There is always the possibility that some things are changed through legislative intervention, changes to the regulations or whatever, particularly if there were a change of government. But for the time being, we have to assume that, well, for the time being, this is the law as it stands. So but that's a good question. Sorry to interrupt, Christian.
No, go for it. Yes, so likely appealed, but for now, the Coles and Woolworths are stuck with these quite intimidating estimates of remediation costs. So before we get further into the meat of the case, Barney and I thought we should explain a common mistake that's often made by employers. There is a misconception that employees who are engaged under written employment agreements or are paid an annual salary cannot be covered by a modern award.
Can we just go to the next slide, please? Sorry.
Yes, next slide. Sorry. Thank you. If you're listening along, as I said that and sort of going, damn, I thought that, if my employees were covered by an annual salary, I wouldn't have to worry about award entitlements. You're not alone. We have plenty of clients who, when we inquire as to a certain employee's award coverage in their business, they reply with pretty unwavering confidence that, this particular employee can't be covered by a modern award because they're either on a common law contract or because they're covered by a salary. But unfortunately, yeah, they can. And modern awards are here to stay, and they're hard to avoid. And they arise completely independently of any contractual arrangement, modern award entitlements and coverage, and it cannot be limited by private agreement. It's certainly permissible to pay an award covered employee an annual salary, but the salary doesn't displace any underlying award entitlements. These entitlements must sort of be properly understood by your business and carefully tracked for the purposes of comparison to their annual salary remuneration, and to ensure that they are being paid either over the award amount or what they should be entitled to under the award. Next slide, and over to Barney to take a bit of a deeper dive into set-off clauses and the hierarchy of employment law.
Thanks, Christian. Yeah, so just to kind of take a bit of a step back here, and to kind of contextualize a bit of this, as we say, the hierarchy of these different documents. A lot of the time, people lose sight of the fact that employment agreements, as I said, are very important. It's a key document that sort of creates the employment relationship, but it doesn't exist in a vacuum. And all too often, people sort of look at their employment contracts and sort of assume that everything can be taken at face value. Some clauses of employment agreements might not be enforceable for a whole variety of reasons. They could be inconsistent with any different number of other sort of higher level sources of law. So in the Australian employment law context, at the very top, we've got sort of legislation effectively, and most relevantly in the employment context, you've got the Fair Work Act, which sets out the national employment standards. So those are kind of like your absolute top level basic entitlements and rights, and nothing else. Anything else that's inconsistent with any of those is going to be invalid and of no effect. And that includes things like, the right to take annual leave, the right to take parental leave, the right to make flexible working requests, right to be paid certain amounts in relation to performance of work. Now, superannuation is included as well. So all those types of things and other parts of the Act, not just the NES, those are kind of sitting at the very top. So then you've got modern awards, which most of you are probably aware are kind of industrial instruments is the sort of broader term that we use to describe modern awards and enterprise agreements, because they're not employment agreements, but they are sources of kind of rights and entitlements and obligations between parties in an employment context. Those modern awards are made and varied and updated by the Fair Work Commission. So the Fair Work Act basically sets out in quite a lot of detail the things that modern awards can and can't do, what they have to include and what they cannot include. So there's a lot of sort of parameters and limitations. So it is actually possible that, the Fair Work Commission could make a change to a modern award, and then for a court to subsequently determine, well, no, that's actually inconsistent with the provisions in the Fair Work Act that specify, that set parameters around the Fair Work Commission's ability to make those instruments. So it is, generally speaking, you should assume that whatever's in a modern award kind of is correct, because it does go through a pretty rigorous process, and it is sort of subject to judicial review or whatever. But I'm just kind of making the point that theoretically they're not totally at large, and they do kind of fit into that hierarchy where they're kind of made under the Fair Work Act. They're never going to have anything that's inconsistent with the national employment standards, and they're basically just building on that to create some more industry or occupation specific provisions, setting out things like hours of work relevantly for our purposes, and overtime, penalty rates, all that kind of stuff, which doesn't apply in a blanket fashion. It kind of applies in that more context specific way that's relevant for particular occupations and industries. There's more than 120 modern awards. So obviously it's tricky for us in terms of, we work with clients across all different industries and with employees in different occupations. So we kind of there are a lot of similarities and common sort of aspects between these documents and how they're set out, but there are nuanced differences as well, which can sort of create complications. more than one modern award can apply to any particular business, and often employers don't realize that as well. So we would have clients that have 3 or sometimes even 4 different modern awards that apply to different parts of their business and people doing different things. So it can get quite difficult to keep track of. Enterprise agreements, as I said, are also industrial instruments, and they often can replace modern awards. So once they apply, they can sort of do away with the modern awards, so to speak. But when they're approved, they have to be benchmarked against modern awards to make sure that employees are better off overall under the enterprise agreement than what they would be under the modern award. So you can kind of see that it still maintains that integrity where it's like, yes, you can displace the modern award, but it has to, displace the modern award, but it has to be consistent and leave employees better off overall. And again, enterprise agreements also can't be inconsistent with the NES. There's a lot of provisions in the Fair Work Act that deal with how they can be made, what they can and can't contain, mandatory terms, prohibited terms, all that kind of stuff. Then once you've kind of gotten down to that bottom level, then you're sort of at the level of the employment contract where, and I'll say it again, employment contracts are extremely important. It's important to have, to make sure they cover all the things that they can, and there's a lot of things that you would deal with in an employment agreement that they're just not dealt with in modern awards or in the NEST. So things like, for example, the obligation to attend fitness for work assessments, consent to particular things in relation to intellectual property and waiver of moral rights, things around confidential information, all that kind of stuff. And so there's a lot of work for enterprise agreements to do. And generally speaking, you can agree to anything with the employee as long as it's not inconsistent with any of these higher level instruments. But that's obviously where the sort of issues arise and that's basically what happened in the Coles and Woolies case, is that some of the clauses in that agreement were actually inconsistent with some of the things in the Act and modern awards. So then right at the very bottom, you've got your company policies. And we'll sort of talk a little bit about things like overtime policies, which can be really relevant for managing some of these risks. But again, a policy, to the extent it's inconsistent with an employment agreement, is going to be invalidated, because if you've agreed to those terms with an employee and then you try to impose a policy on them that's inconsistent with that, the employment contract's going to prevail. So just really important to understand that there is this kind of broader, more complex framework of different levels of regulation, and they all have to kind of be, it all sort of goes up towards the top, and you can't necessarily just assume that something in an employment contract is binding if it's inconsistent with these other laws, and same goes for a policy. So it's important to be aware of that broader context, and to sort of take advice about or to make sure you understand what these other obligations are and how they fit into the sort of bigger picture. So we can go to the next page. So apologies for the wall of text here, and this might be a little bit difficult to read, but this is an extract from the Coles and Woolworths judgment. And this is just a little bit of a look at those set-off clauses that we alluded to previously. And basically what those do is they, and you'll see if you read the text of this, it's something to the effect that, we're going to pay you an annual salary. It's intended to satisfy all of your entitlements, all of your award entitlements, any of your entitlements under another industrial instrument. It's in full and final satisfaction. And you agree that basically, to the extent we're paying you a salary, that can be set off against those modern award entitlements. So there's no duplication. So it's not a situation where, you've agreed contractually to pay me a salary, but you also owe me all these other entitlements under a modern award. The purpose of this is to basically say, we're paying you a salary, and that's for all of your award entitlements. Now, there's all sorts of issues that can arise in this sort of context, but what the big issue, the big problem that Coles and Woolies had in this particular decision was around the timing of payments. So Christian already alluded to this idea of, paying employees what's due to them under modern awards within a particular pay period. And that was really the kind of contentious issue, one of the really key contentious issues in this case. Because and this is from a Woolworths employment agreement. This is one of the clauses. As Christian said, there were like 4 different proceedings in parallel, thousands of employees. There were kind of representative class actions. So it was a very long and complex judgment. There were all sorts of different agreements in play, but this one's just sort of a good example of the issues. So the agreement basically said, we're going to pay you a salary, and we're going to basically create a pool of that salary over a 26-week period. And then if you imagine that an employee has entitlements over that same 26-week period, 6 months under the award, they're basically saying, any overs in one month can be set off against unders in another month or sort of pay period. So basically, it's a running pool. Yeah, you might get paid less than what you're entitled to under the award in some weeks or some fortnights, depending on the pay cycle. But if you get overpaid in another month, it's kind of all going to be set off against it itself. And, as long as you're not underpaid on net over that 6 month period, well, then it's fine. We've kind of done what we need to do. So if we could go to the next slide there. And basically, the court said, no, you can't do that. They said that because Section 323 of the Fair Work Act very clearly says that employees have to be paid amounts that are due to them for the performance of work, like when the work's performed. Basically, that means that employees have to be paid amounts that are due to them in each pay period that those amounts become due. So it's not permissible to say, like, even if you imagine you've got a situation where an employee's got a salary that puts them well above the sort of minimum rates for ordinary hours under a modern award, they might be getting overpaid every pay period by, say $200 just to make up a figure. But if you then get to a period where they're actually being underpaid, you can't rely on those sort of past overpayments to kind of set off the underpayment in any given pay period. And there was a widespread kind of view that was held that was permissible. Obviously, this is reflected in the employment agreements that Coles and Woolies prepared that no doubt would have been drafted by some top tier law firm. Our view has long been that Section 323 of the Act kind of it has this result, but it wasn't kind of a settled sort of view, and there hadn't actually been any cases that had really kind of clearly spelt this out. So there's a long body of case law around sort of set-offs and how it works and what the limitations are, but this is one particular point that had never really clearly directly been ruled on by a court. So it created quite a bit of a shock for sort of the supermarkets, for a lot of other observers as well. And as I said, that kind of implication there is that you have to think about every discrete pay period, whether that's monthly, weekly, or fortnightly. You have to think about it as kind of a self-contained period, and you have to ensure that employees are paid at least what they're owed within each such pay period under an industrial instrument. So if you've set a salary that sort of results in employees being, regularly overpaid, but then you're going to have some real peak period where there's a hectic amount of overtime, then because you can't call on those past sort of overpayments to set off the underpayment, can have implications for how you kind of structure and plan remuneration, because you're not able to do that. I think just to give sort of a concrete example, the one example I like to use is annual leave loading. So if you imagine you're setting a salary package for an employee and you're kind of putting all the components together, assuming you've kind of identified that they're covered by a modern award, you've identified the correct award, you've identified what their classification is under the award, you're comfortable that you understand what all the entitlements they have are, you would then say, okay, well, I can see they're entitled to annual leave loading. It's generally 17.5% of the minimum rate for the times that they take annual leave. And a common approach would be to say, okay, well, employees entitled to 4 weeks of annual leave every year. So I'm going to pay a loading of 17.5% on 4 weeks. I'm going to basically just build that into the salary, which means that it gets spread out across the entire year. So they're effectively getting a slightly higher payment each month to kind of, over the course of a year, pay the full amount that they'd be entitled to. Well, because of this kind of temporal limitation, that's not necessarily going to be a sufficient approach, because unless the salary you're paying to the employee is 17.5%, at least 17.5% above the minimum rate that applies to them, well, if they took annual leave for an entire pay period, they're going to be entitled to a 17.5% loading for that entire period. So unless their salary is at least 17.5% above the award, there's going to be an underpayment. Because when you spread that payment out across the year, it's kind of getting trickled through to them in dribs and drabs. But when you have that period of like a really concentrated period of annual leave, that's going to kind of peak the underlying award entitlement, and the salary might not be sufficient. There's also all sorts of other assumptions that you're making. For example, that the employee will actually take that at all their weeks of annual leave in that given year, whereas they might only take 2 that year and then take more the next year. And of course, salaries tend to go up over time, which means that if the employee takes the annual leave in a subsequent year, it's likely to be at some higher rate that applies under the award. So there's all sorts of issues that you can run into in terms of trying to make that assumption and cater to that in advance by building it into the salary. And likewise for all sorts of other different entitlements, you can run into these kind of problems. So what seems like a really kind of simple process, when you consider the fact that you have to make the employee whole within each pay period, it's sort of, it means that annual salaries aren't necessarily as simple and attractive a way for remunerating award coveted employees as might first appear to be the case. Because the whole point is, you want to set and forget, probably looking at market salaries and kind of assuming that whatever the market rate is probably accounts for all the minimum entitlements. But as we can see from this decision where Coles and Woolies got it so wrong, even really sophisticated organisations aren't necessarily across all that. So you can't necessarily sort of safely make that assumption. Next slide, please. And over to you, Christian.
Alrighty. So plenty of information coming thick and fast, but this is our first sort of set of practical takeaways for you guys as employers. When faced with what seems to be the enormity of addressing all the ramifications of this decision, and to make sure you can avoid underpaying some of your staff, which is the most critical part of these takeaways. So firstly, periodically auditing salaried roles to determine which employees are covered by modern awards and what classification applies to them is certainly recommended by us. Award coverage and especially their classification under the award coverage can shift over time as duties evolve. Employees get promoted, roles and teams are restructured, and awards are periodically updated every year. So many businesses don't realise that they could be covered by more than one award in respect of different employees who are engaged in different activities. There's more than 110 different modern awards. So obtaining advice and assistance, we do strongly recommend for this area. You can get lost amongst, all those different modern awards and the different classifications. If your business doesn't get this first step right, it can essentially be impossible to make a proper or valid assessment of whether an employee's remuneration is actually sufficient to meet their applicable minimum entitlements under the awards. Secondly, sort of in a forecasting way, actively testing salary payments against award entitlements within certain pay periods is a good strategy. This involves sort of modelling foreseeable scenarios throughout the year, such as peak periods where hours of work may temporarily increase. Looking at roster variations, those times of the years when employees may be working public holidays, if this is required in your business, and periods of sustained overtime. By comparing this and stress testing it against their remuneration and their actual patterns of work throughout the year, employers such as you can assess whether an employee's salary actually genuinely compensates them for the minimum wages and penalty rates, overtime, loadings that they're entitled to under those awards. Thirdly, careful review of employment agreements is certainly essential, goes without saying, particularly in terms of the operation and wording of set-off clauses, which Barney has talked you through. The decision itself highlights that these clauses must be really precise about which entitlements are being satisfied by the salary and how the set-off clause is actually intended to function. So vague and generic wording will no longer be sufficient for these clauses following this decision. Your employment agreements should clearly identify the award provisions that are being offset and should also show clearly how the salary does in fact cover those amounts that the employees are entitled to. Finally, Barney also alluded to overtime policies. It's very important to have clear overtime policies that are actively enforced by you as the business owners or employers. In the age of hybrid working, which we're all very familiar with, depending on your workforce, employees can and often do attempt to assert that they've been working overtime unbeknownst to you. They might have logged on at 3 a.m. to respond to an email despite not being asked or required to do so. That's more of an extreme example, but similar disputes do arise, and we have seen them in our practice where employees claim that they may not have been expressly directed to work overtime, but their workload was such that they realistically had no other choice than to, stay late a few hours or log on at home after 9 p.m. So this is where that challenge is with working with salaried employees and the white collar industry, is that it can get a bit vague when people are working overtime, and especially when we're completely connected to our devices and people are taking laptops home, it can get quite tricky. So policies that require pre-approval of overtime and that clarify your expectations as an employer can help resist these kinds of arguments that can crop up from employees suddenly claiming that they've been working overtime when you had no idea. Cool. So we'll go to the next section of the presentation. So the next slide, please. We're going to have a bit of a look into the record keeping failures and specific overtime obligations of our two favourite supermarkets, who unfortunately haven't done a few things right here as well. Before we dive into this section, I would like to just run you through the record keeping framework that's imposed by the Fair Work regulations, just so we're all clear on that. So the specific regulations are regulations, you can stay on this side. Regulation 3.33, firstly, which is concerned with pay records and the recording of employee entitlements. So broadly, what this regulation requires from employers is for them to make and keep detailed records of amounts that are paid to employees. So this can include their gross and net pay, loadings, monetary allowances, penalty rates, bonuses, and any other sort of separately identifiable components of their remuneration. Detailed records needs to be kept of all of this. So this reg is directed at ensuring that for each pay period, as we've sort of said a few times during this presentation, there is a clear and accurate record of what an employee was paid and the nature of those payments. So in effect, the regulation is designed so that employers keep a paper trail that would enable a person who examines these records to understand how an employee's remuneration was structured and delivered to them over time. The second regulation in the framework that was specifically discussed in this case was Regulation 3.34. And by contrast to the last one, it is directed specifically towards overtime and hours worked where time-based entitlements arise. So what we mean by that is for employees covered by a modern award where those employees work overtime, a separate record must be kept of those additional overtime hours. So this applies even if they are engaged on an annual salary, as we've said, that's intended to compensate for all of their award entitlements or where they're being paid an over award amount. So employers under this reg are obligated to keep records of the days the employee worked overtime, the hours of overtime worked on each day, and quite crucially, the start and finish times of when those overtime hours were worked. Not the start and finish times of their total hours worked for the day, but of the specific overtime hours worked. And the purpose of this provision is to ensure that there's an objective record of when those additional hours were worked. And just by the way, the Fair Work Ombudsman does provide some good guidance on how employers can meet, your obligations under the record keeping regulations. So there's some really good resources online that you can check out prior to getting legal advice. But yes, back to our favourite supermarkets. So you can go to the next slide now. We'll have a look at how specifically Coles and Woolworths failed to comply with their record keeping obligations. So in the judgment, Justice Perham, who delivered the judgment, was pretty unequivocal in his wording that both retailers had record keeping obligations under both regulations that I've just set out and that they did not comply with these obligations. So why did they fail? Again, it was an over-reliance on these all-inclusive annual salaries. The retailers' fundamental mistakes was that they had a belief that because they paid these all-inclusive annual salaries and relied on the set-off clauses that Barney just took you through, they therefore became quite lax towards keeping detailed itemised records of overtime or award or penalties under the awards. So Justice Perham summarised pretty clinically that the relevant contractual set-off clauses for both Coles and Woolworths did not have the effect of relieving these record-keeping obligations. He specifically highlighted that for Woolworths, they did not keep what I just touched on before, which was the separately identifiable amounts of loadings, penalty rates, or monetary allowances. There was no records of that, nor did they keep a record of the number of overtime hours worked by the employees, or crucially, when they started and finished those additional hours. Very similar reasoning was applied to Coles by the court. And at this point, you might be wondering, what did Coles and Woolworths actually do right? Did they have some records? Being the two biggest supermarket retailers in Australia, you would consider they would have records of some things, and they did. They both argued that they maintained rosters and extensive record keeping data, including published rosters, which were the rosters that were printed out and displayed in the common area in the business, clock in and out timestamps for the entire day, though, not for overtime specifically. And they also had payroll records showing total hours worked by the employees. Woolworths submitted during the case that it did, in fact, keep adequate records as required for the purposes of the regulations, and that the record keeping information could be deduced from a combination of the rosters that they kept and the clock in and out timestamp records. This was a problem, however, in the eyes of the court for a few reasons. Firstly, the records had to explicitly specify the overtime hours worked, as I've stated, and the start and finish time of the overtime hours. And they also must be what's called readily accessible and usable by a Fair Work inspector without having to interpret or reconstruct the record from two different sets or multiple sets of data. And thirdly, the record must also be capable of being copied and made available to an employee or a former employee who requests to see those records that pertain to them. So essentially what the court was getting at here was that we can't have a whole mess of different records and have that satisfy the direct and specific separately identifiable records that are required under the regulations. We need to just be able to grab those records when we need them, see when they work the overtime, and that's it. We shouldn't have to compile it from multiple data sets. So the court was, pretty unequivocal on this point. Justice Parham said that the synthesis of when overtime work from these different data sets definitely does not constitute a record of the information required under the regulations. And specifically for Woolworths, he was quite emphatic in this point, but he also applied much of the same reasoning to Coles. And in terms of Coles' failures, additionally, they came under a bit of further scrutiny in the judgment as their records were actually often incomplete or unreliable, particularly in relation to the hours actually worked by the employees. Before September 2017, the clocking in and out data was absent for most of the salaried employees tested in the decision. And the clocking data was often manipulated or was incomplete in terms of the rostered records and was manipulated to reflect attendance after it happened. So there was quite a few issues in Coles, data, and also Woolworths was able to put forward better evidence towards how they combined their data sets, and Barney will touch on that shortly when we talk on the reverse onus. So I will move to the next slide now, Barney.
Thanks, Christian.
No worries.
Yeah. So look, just this is another sort of aspect of this decision that was quite interesting. So since 2017, there's been it's a bit some parts of it are a bit technical, so I'll just sort of touch on it briefly. But it's basically since 2017, there's been a reverse onus of proof, which means that if an employer fails to keep particular records that they are required to keep under the regulations, and an employee makes an allegation of underpayment, then essentially the onus shifts to the employer to disprove the allegations that are made by the employee so far as they relate to matters that would have been established by the relevant records if they had been kept. So that means that, if you don't have the relevant records, basically an employee can assert, I've worked X number of hours or, done whatever, and the onus will be on the business to actually disprove that on the balance of probabilities. So look, it's not fatal, and in fact, as Christian said, with Woolworths, they had all the relevant information there, but it was just that because the court said the whole purpose of the regulations is that if a Fair Work Ombudsman inspector rocks up, they need to be able to just grab the records really quickly and see exactly how much overtime an employee worked. So Woolworths had the data there. They had the rosters, which would show ordinary hours, and they had the exact clock in and clock out times. So you could put them all together and figure out, okay, well, these were the ordinary hours. Therefore, what remains was the overtime. But the court just said that's not the purpose of the record keeping obligations. It's supposed to be a self-contained, easy, accessible record. But so that meant that they had failed to comply with the record keeping obligations. The reverse onus of proof was engaged, but they were in a somewhat better position to actually then discharge that onus because they were able themselves and their lawyers to do that exercise of going through and synthesizing all that data and going like, well, this is what our records show. They may not comply with the act, but they do actually, sorry, the regulations, but they do actually sort of provide the relevant information. So it didn't turn out to be a huge kind of pivotal issue on Woolworth's side so much because the reverse owners was engaged, but they were kind of able to deal with it. Obviously, that still then established they had underpaid people. So, and even, just failing to keep the records is still what we call a civil remedy contravention under the Fair Work Act. So it does expose you to penalties. So there can be liability just for that technical breach per se, and significant penalties could be imposed. Obviously it's not good to be on the back foot to start off with where you've kind of got that onus, and it's something that employees can kind of throw at you if they're threatening underpayment claims to kind of say, well, do you have all the correct records? Because if you don't, this is what I'm going to say, and it's going to be your problem to disprove it. So definitely something important to bear in mind that came into play here. If we could go to the next slide, please. So look, the upshot of all this is, a lot of this stuff has come as quite a shock to a lot of businesses. And, you can pretty much guarantee that if Coles and Woolies, take Woolworths, for example, where they did have more complete data, they did have full clock in and clock out times, they had rosters, most businesses would have thought before this decision that should be sufficient. So, most businesses, I would wager, in the country, from very sophisticated ones to less well-resourced businesses, are likely to have some kind of issues or exposure in relation to all this record keeping stuff. This is probably the aspect of the decision that I suspect will be most vehemently appealed, and could even potentially be sort of subject to some kind of regulatory change. But for the time being, this is the law as it stands, and it does create an ongoing risk to businesses if they don't comply. As Christian alluded to already, there are some sort of documents on the Fair Work Ombudsman website that give examples of what they say kind of correct sort of proper records should look like for these various things. But it is an ongoing effort to kind of put the systems in place to maintain them. And more than that, with salaried employees in particular, a lot of employers just aren't recording the hours that they're actually working to begin with. And businesses have to kind of look at that very carefully and kind of think about the sustainability of that type of arrangement and how they're going to manage it. I think you either have to make explicitly clear to employees who are on a salary that they're only expected to work their contractual hours, and that, as Christian said, have some type of policy that requires approval for any hours beyond that. But even then, it is going to be a constant effort to monitor and enforce that. It's not a silver bullet because employees can always make that argument that, well, yeah, you said that, but like you gave me all this work that I had to do by Monday, so how else could I possibly do it other than to work overtime? So there's always going to be those kind of disputes that arise on the border, but at a minimum, this issue needs to be kind of looked at very carefully and considered, and you need to have a strategy about, okay, what are the risks we have here? How are we managing those? And what sort of combination of tools are we using to kind of try to mitigate those risks through employment contracts, through policies, through ideally having some mechanism to actually record starting and finishing times, because for employed, some salaried employees won't be covered by modern reports, and if so, that's great. You don't have to worry about it. There will still be record keeping obligations. You need to carefully consider what those are, but for present purposes, we're just focusing mainly on that kind of situation that arises. It's especially acute for salaried employees. It applies to non-salaried employees too, but particularly those modern award covered employees. So it is kind of, there's a lot to consider there, and a lot that the businesses now need to look at and think about. Okay, how are we managing this risk? because, if you get an underpayment claim from a sort of dissatisfied employee, they've got that reverse onus they can throw at you. They can make a request just before, their lawyers can make a request right up front. Okay, we want to see all the records, because they've got a right to request those under the Act. If there's holes or issues there, they're going to be saying, well, this is what I'm saying I worked. You're going to have to disprove that. There's going to be, it puts you in a really difficult position. So considering that carefully and thinking about what you're doing to manage that risk is really essential, because, if you get one employee sort of bringing an issue, it could turn into more. You could get sort of the Fair Work Ombudsman involved, who are then kind of doing a full investigation, and it can get out of hand very quickly. So it's important to kind of consider in advance what is going to be done in relation to that. I can see that Chris has asked, is there's a rule of thumb regarding whether someone is an award-based employee or not, or does it depend on the award? It does ultimately depend on the particular award, which is what's so tricky, because there's 120 odd different awards and they all have their own coverage clauses. And then sometimes they have clauses that say, well, this award applies to the exclusion of this other award. So you might think, oh, well, they could be covered by this one, they could be covered by that one. You sort of need to then look at both and determine, well, this one says that it applies to the exclusion of this other one. It's, really most businesses are going to be covered by probably 1 to 4 modern awards. And the important thing is to have a clear idea of what the awards are that cover your business. Best to get legal advice when you make that initial decision, because as Christian said, that we go back to that hierarchy where that modern award sits there above the employment contract. It's going to determine all of the sort of issues around ordinary hours, rostering, penalties, all that kind of stuff. And if you don't get that initial assessment right, it's just you don't have a chance of having any real idea of whether you're compliant with all these other obligations. So there are certain roles that are typically not covered by modern awards. Like HR professionals, accountants, lawyers are not covered by modern awards, other than sort of graduates and support staff. Really senior managerial employees, CEOs, CFOs would not be covered by modern awards. But beyond some of those kind of rules of thumb, you do need to consider, okay, what are the awards that potentially apply to our business? They can be industry based or they can be occupation based. So it could be like, if you're like Coles and Woolies, they're in the retail industry, so they're covered by the General Retail Industry Award. For other businesses, there's a food, beverage, and tobacco manufacturing award that applies to sort of that industry. But even there, if the classifications in that award don't cover certain, for example, administrative or clerical roles, then you probably have the Clerk's Award as well for those employees. So what we do for clients, which is a really important first step for compliance, is we will sort of get all the PDs and an org chart, go through and kind of map out, okay, these are the awards that apply to these different positions. This is the classification based on the PD. And even then, it can vary among individuals performing the same position, depending on what their qualifications are, because sometimes classification under award, like what level you're at, depends on having specific qualifications. Some employees might have them, some might not. And it might be that they're performing the same duties, but just having that qualification sort of bumps them up. So as Christian said, it's not static, it's something that can change. But at least if you get that initial idea and have that map to start off with, then it's a lot easier to manage those ongoing changes and to have a reasonable starting point that you're working from to try to sort of figure all that out. So hopefully that sort of answers that question. And if we can just move to the final slide now. Just to kind of sum up and tie it all together. Obviously, we've covered a few different aspects of the decision. We've looked at sort of underpayments themselves, which arose from those misunderstandings about how setting off works and how an annual salary can discharge award obligations, and specifically that kind of temporal, that time-based limitation around having to satisfy those obligations within each pay period and not being able to do that kind of pooling that Woolies tried to do, where it's like unders and overs across a 6-month period, and as long as it nets out at the end of it, then we're square. So that was kind of the first issue, and that's where you've really got to understand, obviously, what those obligations are and have contracts that sort of put you in the best possible position to kind of take advantage of that. You've got to know what the instruments are and what the classifications are, because otherwise, when you're planning that salary, when you're saying, okay, what's the salary package going to be and how are we going to satisfy ourselves that it meets all the relevant obligations, if you don't know what you're comparing it against, you've got no chance. And then you've got to consider, are we going to pay annual leave loading separately or build into the salary? Because if you build it in, you're making certain assumptions, and you need to consider whether those are justifiable and robust assumptions. Then we looked at sort of the record keeping stuff, which is a whole another sort of challenge in terms of, Are we going to record everybody's hours of work? How are we going to do it? And again, knowing which employees are award free by having done that analysis to figure out which ones are covered by an award, that's going to cut that job down a lot. If you can say, okay, well, we know these employees are award free, we don't need to worry about them. We can just sort of deal with them under the contract. But for the rest that remain, especially if they're not, if they're paid at an hourly rate, as I said, tends to be that you're going to be recording their hours because you need to know for paying them. But it's those salaried employees where a little bit of extra work needs to be done to figure out how you're going to manage that risk. Some other tools that can be used are like individual flexibility agreements. So most awards will provide a mechanism for you to agree with individual employees that the award will apply differently to them. The big proviso is that there have to be certain procedural requirements that are met. The agreement has to be in a particular form. It has to cover off on certain matters, and the employee has to be better off as a result of the agreement. So the textbook example would be like an employee that says that they want to start work early because it suits them for whatever reasons, family commitments, etc. Now, under many awards, there's a spread of hours that's specified, and if you work outside that spread of hours, it's automatically overtime. So even employees saying they want to start at 6 a.m., it may be that under their award, the default position is that that's overtime. And therefore, because you're agreeing to their request they've asked for, their pay, their entitlement to overtime is increasing. So you can put mechanisms in place to manage that a little bit, but it is subject to certain procedural requirements. It has to be done in a particular way. They have to be better off, etc. So Chris has now also asked, how are offsets considered, e.g. time in lieu? So time in lieu is another kind of tool that can be used for managing overtime obligations. But again, it's always subject to the provisions of the particular award. The default position under awards is that employees are entitled to receive payment for overtime as and when it is worked. Time in lieu has to be agreed on each occasion separately in writing. Generally speaking, the awards have slightly different provisions, but mostly they're standardized. Has to be agreed in writing on each separate occasion. And then in that case, you can have a time off in lieu arrangement instead. So it's not a set and forget type of thing. And, some employers sort of try to have a default policy that, will always give you time in lieu rather than paying overtime. But you really do need to pay attention to what the awards say about how time off in lieu can be done, what the requirements are. As I said, written agreement on each occasion, so you can't just have sort of a standing arrangement. You can set up templates that are sort of usable so that you just sort of flick them out every time, or have a form that the employee needs to fill out. So once you do the work and set up the process, it's not necessarily, doesn't need to be the end of the world, but you do need to understand that it's not necessarily as simple as just having a sort of unspoken agreement that people will get toil instead of being paid overtime, because the default position is that employees get paid overtime.
That's Barney, lots to absorb there. Any particular questions for Barney over and above what I've put in the chat?